Our moderator for the debate is Lucy Reed. Lucy is president of the International Congress of Commercial Arbitration and a vice president of the Singapore International Arbitration Center Court. She previously served as a vice president of the ICC Court, president of the American Society of International Law, chair of the ITA, a member of the LCIA Court, and a member of the Hong Kong International Arbitration Center Board. From 2016 through 2019, Lucy was the director of the Center for International Law and a professor on the law faculty of the National University of Singapore. From 1998 until 2016, Lucy was a partner with Freshfields, where she led the firm's Global International Arbitration Group. Lucy is currently a leading arbitrator with arbitration chambers based out of New York, specializing in investor state and complex international commercial disputes. Even with all of these accomplishments under her belt, Lucy has always wanted to be a referee for a prize fight. Lucy, here's your chance. The floor is yours.
Thank you, Kim, and welcome to everyone. Kim has just broken the rule, which was to have a very short introduction to save time for the debate. But thank you, Kim, for that introduction. I welcome especially the Vis Mooties, who are about to have the treat of seeing a splendid battle of advocacy. Often in an Oxford-style debate, the debaters, by definition, have to argue for a position that they do not fully endorse or don't endorse at all. I suspect here that may not be the case, but we will see. Let me introduce for the motion, Neil Kaplan, CBE, QC, SBS. Neil was called to the Bar of England and Wales in 1965. And since 1995, he has been an arbitrator in literally hundreds of commercial and treaty arbitrations, including many of the largest and most complex. He's been president of the Chartered Institute of Arbitrators and served as a judge on the Supreme Court of Hong Kong. For debate purposes, though, I want to mention that Neil had a very accomplished career as a star advocate, a barrister and principal Crown Counsel at the Hong Kong Attorney General's chambers. Neil is a member of my chambers, but I am sure that I will be neutral in listening. We'll see. Now, against the motion are Canadian, the Honorable Ian Binnie, CC, QC. Ian was called to the English bar in 1966. Now, I note that was 1 year later than Neil, so we'll just see if that extra year makes a difference, won't we? Ian had a lauded career as an advocate in Canada and served for nearly 14 years as a justice of the Supreme Court of Canada. And when he retired from the bench in 2011, he was described as arguably the country's premier judge. He authored 170 opinions, probably more, and many arbitration awards since then. So now you've heard me tell you that both Neil and Ian have been advocates and judges and counsel and arbitrators in hundreds of live hearings, probably not so many virtual hearings, at least as yet. Although with Canada and Hong Kong and Australia being on such far-flung time zones, I expect they've had their fair dose of all-nighters again in the past few months. So let's get into the debate. Here's the order of play. We'll start with a poll from the audience, the results of which will be kept secret as to whether you support or not the motion. Then Neil and Ian will each have 15 minutes to present their positions in chief. I may then have a few questions for both before their 5-minute rebuttals. Then we'll have another audience poll to see whether Ian or Neil prevails on the motion. And in case of a tie, I stand ready to cast my vote. So let's get started with the initial poll, please. All right, Neil, please begin.
Thank you very much, Lucy, and good evening, everybody. It's midnight. It's gone midnight here in Melbourne. So I'm delighted to be with you, even though it is that time of the day or night. Congratulations to Arbitration Place for setting up this debate. It's extremely well timed because it was, after all, a year ago yesterday, at least Australian time, that the pandemic was announced by the WHO. And what a year it's been. I don't need to go through the categories of disasters that have befallen the world by not itemizing them. Don't think I'm underestimating them in any way. But you know, every cloud does have a silver lining, and that's what I want to concentrate upon tonight. Speaking personally, I have to say that I've enjoyed not traveling all the time. I've enjoyed working with my wife in developing our culinary skills. And most importantly, I've enjoyed spending more time with her than ever before. I've enjoyed not wearing a suit or a tie. Although this week I did attend a 4-day hearing in person in Melbourne, all dressed up with a tie. But as with all debates, it's very important to have regard to the terms of the motion, the precise terms. And the crucial words are prefers virtual hearings. Now, that doesn't just mean final hearings, but it encompasses all the hearings that you might have on the way to a final award. And it doesn't mean that this House would never countenance an in-person hearing, merely that it would prefer them to be virtual, all things being equal. But it's important, I think, to answer this question, to have in mind all the stages of an arbitration where hearings might be required. And so I'm going to go through quickly about 10 different things that can be done before the main hearing. The first, of course, is the first meeting with the parties. This is crucial because it sets the scene and produces a procedure for the entire case. This can easily be done by Zoom. And when I use the word Zoom, of course, I do mean WebEx and Teams and any other platform. So I'm not giving advertising just to Zoom. Secondly, there are often hearings as to jurisdiction. These are often raised in bilateral investment treaty cases, but they can arise in commercial cases too, such as res judicata, time bar issues, or the scope of the arbitration clause. These are ideal for virtual hearings. Then there's the application for interim measures. These are common and sometimes can be done in writing, but quite often a hearing is preferred. Then there can be difficult questions with the production of documents, and these often relate to privilege and confidentiality, where a hearing might be preferable. And again, this can be done very effectively virtually. And then there can be the initial conclave with the experts to make sure they're working together for the benefit of the tribunal. And then, of course, there's the early opening, a crucial step in most cases, as it gets the tribunal on top of the case sooner rather than later, thus meeting the requirements of the Reed retreat. It also informs the tribunal's subsequent case preparation. And it's an ideal way of doing this virtually. And then, of course, more and more these days, we're seeing mock hearings, or where one side tests its case in front of 1 or 3 mock arbitrators. And again, this helps to improve their presentation, and it's obviously very easy to do it virtually. And then, of course, there is the prompt dealing with any other pre-hearing issues that might arise that need the tribunal's intervention. The use of Zoom and others is a great case management tool, and one that is used more often now than ever before. And then, of course, we have the main hearing. Obviously, the main hearing has to come sometime. But even after the main hearing, there can be a request for a hearing for post-hearing closing submissions. And again, this is sometimes sought. And then, of course, as I said, really, there are situations where hostilities break out between counsel, and the tribunal needs to step in and stop it. So to say to the parties, we'll Zoom tomorrow and sort this out, it shows that this is a very valuable case management tool. Now, like other people, I've been living on Zoom for a year now, and I've had countless hearings, including main hearings. They've all gone extremely well. There's been no breakdown in internet. The screens were perfectly clear. I could see the face of the witness just as clear as I can see Lucy's face now. A very good use was made of electronic bundles, so I wasn't drowning in paper. There were breakout rooms provided through the screen. And it worked extremely well. Now, I accept what I assume my distinguished opponent is likely to say, namely that there's nothing as good as everyone being in the same room for the main hearing. And of course, there's an element of truth in that. I accept that. There are some cases where it's highly desirable for people to be in the same room. I have in mind particularly heavy construction cases where there are detailed plans and schedules that don't give over easily to electronic versions. The opportunity for the expert to lean over your shoulder and point to the specific point in the plan that's the subject matter of the dispute, it is an advantage. Is it better for arbitrators to be in the same room? Of course, it's better for them to be in the same room, but it doesn't mean that it doesn't work perfectly satisfactorily in a virtual environment. Do I miss the social camaraderie with my colleagues, going out to dinner and discussing the case? Of course I do. But we manage pretty well in breakout rooms or in separate Zoom calls to discuss the case. And it works very well. Now, I think there are advantages with virtual hearings over face-to-face hearings. What I found is that people tend to stick better to their allotted time. I find there are less interruptions. The witnesses appear much closer, as I just said, than being in court or in a hearing. And many judges, particularly in Australia, I've heard, who've been dealing with virtual cases, have said they get a much better view of the witness face-to-face on the screen than they ever do in court. There are problems. Of course, there are problems. The time scales can be challenging, as I can attest to, even as I speak. It's past midnight here, as I've said. This week, I sat from 8 a.m. to 1 o'clock. A few weeks ago, I sat from 5 a.m. to 8:30 for 10 days. And it's better than jet lag. At least you can go to sleep afterwards. But think of all the advantages that we're getting from virtual hearings. We're not flying around the world. We're having environmentally friendly hearings. Let's not forget the Green Pledge for arbitration, which I hope will be as successful as the gender pledge that we all entered into a few years ago. A reduced carbon footprint, a huge saving in costs, I'll come to that in a minute, and no jet lag. Some of you listening today, mooting for the first time, may not have any experience of a main merits hearing in a big case. The costs can be huge. So just try and get your head around this. 3 arbitrators and an arbitral secretary flying often from far away, hotel accommodation for them all, 2 teams of counsel flying again from far away. Teams might be 10 to 15 each side, sometimes more, airfares and accommodation. Same for the witnesses. And in BIT cases, it's quite common for the state to send a huge contingent to watch the proceedings, all having to travel, all having to be accommodated. And then you have to have the hearing rooms big enough for everybody and with all the breakout rooms and couriering the documents, boxes and boxes of documents to and fro. Now compare that to a virtual hearing. No hotel, no flights, no boxes, because in virtual hearings, we are much more adept at using electronic bundles. A huge saving in human wear and tear and in cost. Now, I appreciate and I understand, and I would feel the same as counsel, that it's not easy to cross-examine a witness through Zoom. You're missing a lot of the drama that goes around you that you can't see. But this mustn't be the overriding factor. People are getting better at doing it. There are several guides out now how to be an effective cross-examiner on Zoom. And I accept that cross-examining through an interpreter is very hard at the best of times, but additionally so when you do it virtually. But that doesn't mean you should abandon the virtual hearing, surely. It just means you should ensure you get the best, most experienced interpreters. However, in my submission to you, whichever way you look at all this, it's a no-brainer. Another point to bear in mind is that this is not new. We think of it as new, but we've been having partly virtual hearings for years. During the last pandemic, the SARS pandemic, I chaired a tribunal from London when everybody else was in Hong Kong. It worked perfectly well. Instead of an electronic bundle, I had a fax machine by my side, and that tells you how long ago it was. There'd be numerous examples of witnesses who could not travel for various reasons giving their evidence by video. So, am I saying that we will never have face-to-face hearings again? Of course I'm not saying that. But they will be far rarer, in my view, unless everybody is from the same country or from a nearby country once the pandemic has finished. But as the center of international arbitration has moved towards Asia and Australasia, the long distances, costs, and risks can easily be avoided by more use of virtual hearings. At the moment, virtual hearings are a necessity. They're a health necessity, in most places at any rate. We've got used to them. They work, they're cost-effective and efficient. For the vast majority of hearings, I think they are to be preferred for the reasons I've given. So I return to the motion where I began. And in my view, and I hope you agree with me, there's only one answer to the motion. So I ask you to return an affirmative vote, namely agreeing that this House does indeed prefer virtual hearings. And I'd like to add a rider and virtual debates at reasonable hours of the day. Thank you.
Ian, your position against the House motion, please.
Yes, well, thank you very much, Neil, for an interesting presentation. I think it is important to note that Neil has tried to sort of atomize the process so that because it's a good idea to have a documents motion virtually, or a clients meet virtually, you can expand to include the entire motion, which is very broadly that hearings, period, including in particular, I would think, in terms of importance, the merits hearings, should be virtual. So Neil wants all virtual all the time. As he points out, of course, it's not new to have hybrid hearings, particular witnesses being testifying by Zoom and so on. But we're in a new era, and we have to face up to the fact that what is really at stake here is not a continuation of the old practice of using virtual hearings where it works by force majeure. What we're talking about is a preference. We prefer hearings virtually. Now, I think this audience, the voters here, are going to divide along lines of personality. I suspect that those supporting Mr. Kaplan are rather happy that the pandemic has prevented you from going to Vienna. I suspect what you like to do is to sit in your basement or in your kitchen with a computer instead of traveling to the grand sites of Vienna, the city of Mozart and Beethoven, why not sit in Melbourne, where it is nicely nestled up against the Antarctica? If you're one of these people who is glad of social distancing, if you would prefer not to be face-to-face, then of course Neil has your answer. Have a permanent long-distance arrangement with your fellow practitioners, witnesses, and experts the world over. But what I would suggest is, if you want to hear the Vienna Philharmonic in the Grand Concert Hall of Vienna, and you prefer that to seeing a small screen presentation, then you will support the opposition to this strange motion. There's really nothing like, it seems to be, bringing people together. Law is a social profession. Lawyers feed off each other. They like gossip. They meet in the halls. They work together. They concentrate on the matter at hand. They don't stick at home. But of course, if you're one of Mr. Kaplan's supporters, you prefer to stick at home, as he said. Well, do you blame him? He lives in Melbourne. Of course, if you live in Melbourne, you don't want to travel. It takes 24 hours to get anywhere other than Sydney. So it's a personal pleading, really, as I see it, that is being advanced here. Now, I think I have 4 reasons, which I will briefly discuss. Firstly, that the merits hearing, and that's the guts of this issue, no matter how much Mr. Kaplan seeks to distract, is to get at the truth. And I believe you have a better chance of getting the truth when all of the witnesses, all of the tribunal members, and the clients are all in the same room in the same time zone. Secondly, I think that face-to-face hearings promote dispute resolution. You know, these hearings are not some abstract proposition. They're designed to reach a result beneficial to the clients, to resolve the disputes. And more disputes will be resolved in the course of hearings person to person than can ever be done by clicking away on the television set. Thirdly, more things can go wrong with a virtual hearing than in a face-to-face hearing. And finally, I'm concerned about the future of the profession. It's one thing that lawyers, having learned their skills in an era of face-to-face presentations, can translate those skills to a new medium, to the virtual hearing. But what about the lawyers who've never had an opportunity to develop those face-to-face skills? What about the lawyers who've never had the sense of collegiality, of dealing with their opposite numbers in a hearing, like the grand Japanese room at the Peace Palace in Amsterdam? Of course, if you prefer to do your litigation from an office rather than the Japanese room at the Peace Palace, you will vote for Mr. Kaplan. Now, on the hearing question. A hearing is a theater. There are all sorts of things going on in that theater, in the hearing room, than simply what is picked up with a camera on the face of the lawyer and the witness and the arbitrators. This is a very good case to illustrate that. You've got Mr. Mueller, who is the CEO of Ross, who's going to try to persuade people that COVID-19 is related to malaria. Of course, it's a nonsense proposition. Malaria is spread by mosquitoes. COVID by airborne transmission. COVID is a virus. Malaria is a parasite. One works through blood constricting the access to the brain. The other deals in respiratory failure. So I want actually to see Mr. Mueller in a box in front of his peers, not isolated in a room with a television set, putting on a show. I want to see him sweat. I want to watch his lawyer shifting his feet uncomfortably as some of this nonsense comes out. I want to see the sort of coached presentation that he's been given by his lawyer disintegrate under the pressure that can only really be created in an actual hearing. You know, as Mike Tyson used to say, everybody's got a game plan until you get hit in the mouth. And it's when the witness gets hit in the mouth that the fun begins, and you only see the fun if you're in the room. And what about Ms. Huber? How is she going to explain her conflict of interest, working first of all with Ross to put together this agreement that everybody's fighting over, and then she switches to the claimant and she's busy upending the very agreement she attempted to negotiate. You know, these are bombshell issues that will explode in a person-to-person hearing where everybody can see everybody else in the same time zone as the hearing progresses. Neil mentioned, well, it's midnight in Melbourne, it's 8 o'clock in Toronto. If we had somebody here from New Zealand, it would be 2 o'clock in the morning in Auckland. I don't know whether Neil is prepared to start a hearing at midnight in Melbourne. And if he does, and he's shaking his head, I expect he's not at his best. I would think Neil is probably better during normal circadian rhythms than forced into an arena at midnight to conduct a cross-examination that will go on for the next 8 hours. Of course, Zoom hearings aren't 8 hours because there's so many different time zones, there has to be a compromise. So the evidence gets in slowly and disjointedly. Now, promote dispute resolution. Cases should settle. Clients want to settle. In this case, you've got a startup claimant. You've got a respondent who's in the business of patents and licensing technology to the very people like the claimant. You've got an internal dispute over a contract. You've got a situation where the claimant doesn't, and Ross don't want to sue each other. They want to settle. They've had negotiations. They've been unable to reach a deal. Where deals get reached is at the in-person hearing, over coffee, in the washroom, at the hotel breakfast, informal discussion. You know, will your people take $3.5 million? I don't think so, but I might get them to 4. All right. Cases start to settle. You don't have that on virtual hearings. By definition, you're located all over the world, and all you see each other is the small screen. Now, I said that more things can go wrong in virtual hearings than face-to-face. I've had 2 personal examples in the last month. There was a hearing involving an expert who was doing his thing from home. There were about 20 people on the line, various clients and so on and so forth, the arbitrators, and there was an annoying dog somewhere. And I said, you know, would people please mute? And the witness said, well, I'm afraid the dog is in my house and my wife is out and I can't deal with it. So we proceeded with the dog yapping. We proceeded with the lawyer trying to ask questions. We proceeded with the witness's focus, which was completely dissolved by this unexpected eventuality. You really feel like saying to the dog and the witness, one at a time, please, you know, to try to gain some coherence out of the session. But we labored through to the end with what I think was a much prejudiced hearing. Then 2 nights ago, I had a hearing. There was a Lebanese expert testifying from Beirut, and he was in the middle of explaining some intricacy of Lebanese law of fiduciaries. And there was a commotion, and I said, what was the commotion? It was a riot outside his office. You know, the anti-government protests moving down the main streets in the evening, because it was evening in Beirut. So we continued. But these things happen. They don't happen all the time. Often virtual hearings work quite smoothly. The disadvantages are that you're missing the full experience of an in-person hearing, not that the technology has a particular issue. So finally, about the profession. You know, the future is about you. The mooters, the people who've been denied the opportunity this year to go to Vienna to join people from all over the world, to meet together, to talk, to network, and to have a wonderful time. You want to learn skills. You want to learn skills when you're young. You want to learn skills in courtrooms. That's where you, or arbitration rooms, or tribunal rooms. But you want to be on your feet, and you want to experience the whole situation, not simply what can appear on the small screen. I don't know whether these skills that lawyers have picked up over the years can be handed down to younger lawyers who've never seen anything other than a hearing on Zoom. I don't think you have the same energy. I don't think you have the same tension. I don't think you learn as quickly without that kind of pressure. The pressure is really what forces a hearing to focus and to bring out the truth. So I think it would be an enormous error if the legal profession were to pivot because, the cost of flying Mr. Kaplan from Melbourne to Vienna is more expensive than a Zoom line, to allow that kind of concern to determine the future. A couple of hours of Mr. Kaplan's time will pay for his airfare from Melbourne to Vienna. And overall, in the scheme of things, these costs are not prohibitive, they're not great. If there is a 20% advantage in getting at the truth of a hearing, in getting the issues out on the table, to understanding the credibility of witnesses, only a 20% margin in an in-person hearing over in a virtual hearing, that is the 20% that lawyers and arbitrators are interested in. That's the 20% that determines cases. And on that basis, I would oppose any idea that this House prefers virtual hearings, regardless of the circumstances.
Thank you. Before your rebuttals, I want to pose two questions I hope you would address naturally anyway in your rebuttals. The first is I want to press you to say what is the overriding factor in favor of the motion and against the motion. The overriding factor. This is just what a tribunal might ask you or ask the mooters. Second, neither of you mentioned a topic that has come up in discussions about virtual hearings, which is the bias, most likely an unconscious bias, that comes up when tribunal members have past personal familiarity with other members of the tribunal or council from real life, from that in-the-room experience that you've just heard about we've just heard about from each of you. When you've got someone you know very well already and trust very well from real life, and on the screen, there are others whom you don't know, except in two dimensions. Is that something that would sway your support for or against the motion? Over to you, Neil, for your rebuttal. 5 minutes.
Right, thank you very much. Well, I thought it was a great shame that Ian didn't really get to grips with the main point that I was making. I wasn't saying there should never be full hearings. He didn't get to grips with all the other hearings that there are that don't require witnesses during the course of an arbitration. And some of these hearings are extremely important and they're very expensive because they involve a lot of people and law and getting together if you have to travel. And so you can't just say, I prefer the main hearing to be in person because it's good for young lawyers and it's good for everyone to get together and have a drink and it's good for people to go to the loo and try and settle the cases. It doesn't work like that anymore, I'm afraid. The costs are far too high. The amounts at stake are far too high in most of the cases that we're talking about. Let me just say this about young lawyers. Young lawyers will still cut their teeth on domestic cases. There will be domestic cases in state courts. There will be domestic arbitrations where they can go in their own city and learn their skills. So that's the first thing. The second thing is, I think Ian completely underestimates the cost. I've been doing this now for over a quarter of a century, and I've been through a number of bills, and I can see what a huge amount of money is spent by having to travel many times all the way around the world. I'm sorry that Ian was disconcerted by the dog barking, and I can understand how irritating that was. On the other hand, he could have easily been sitting in Arbitration Place while the next door building was doing some very heavy work and drilling and interrupting him in that way. So I don't think that's a very strong point, if I may say so. I agree things can go wrong. You started off by talking about the Vienna moot. I never said the Vienna moot should be virtual. I can't wait for the Vienna moot to be real. I want to be there. I want to be in the opening session. I want to be at the opera and at the concert halls and to meet with all the students as I've done over many years. Of course, that will go back to normal when it can. But I think we have to be realistic about whether most of the stages in arbitration can genuinely justify flying halfway around the world for a half-a-day meeting in the Japanese room or somewhere else. Lucy, the overriding factor. I mean, the overriding factor must be convenience. It's a wide word, I accept. That includes looking at the cost and looking at whether all the expense is justified for the hearing. There will be cases where it is important to have a face-to-face hearing, where there are serious issues of credibility. My experience is there are not that many cases around that turn on credibility. Lucy has herself written about the dangers of witness recollection, and so has Toby Landau, and their comments are well-founded. So most of the cases I do not turn on witness recollection. And if there is a case which really depends on who's telling the truth about this or that, I accept Ian's point, but there are not that many cases around. On the question of bias, I don't think that's a fair point. It is true there will be people on the other end of the screen who you know, and there will be people on the other end of the screen who you don't know. I mean, that happens in real life. I don't think that matters. I mean, if you're a fair-minded, independent arbitrator, you're only concerned at the merits of what's being said, not who's saying it. So I'm not particularly worried about that point. So I think that the idea that you can fly a whole team of people halfway around the world for a short meeting that's not the final hearing, I think is something that we won't countenance. And there will always be exceptions. There may be a hearing that is so important that they want everybody to be there and they're prepared to pay for it. So be it. But in most cases, we have to consider time, cost, and wear and tear on the body and the planet. I noticed at the end didn't mention a word about the great advantages environmentally of not flying everywhere all the time. Thank you.
Thank you, Neil. Ian, your rebuttal, 5 minutes, please.
Yes, well, on the first point that you raise as to what is the major point against the virtual hearing, it is what was the first point on my list, which is the advantage that it has in getting at the truth, because you're operating considered well-worked machinery in an in-person environment, with all the advantages that I was discussing. I think, on this unconscious bias, it's an issue that is across the board. To some extent, these organizations like the World Bank and the LCIA have conferences and meetings and networks. Those aren't hearings, those are opportunities. Neil said he'd love to fly to Vienna as soon as he's allowed to for the viz moot. Well, it rather undermines the virtues of a virtual hearing, which is the way today's, this present moot is going to occur. If he wants to abandon the virtual hearing and get to Vienna as fast as Qantas can get him there. What he's really trying to do is to say, well, when the motion says a preference hearing prefers virtual hearings, he says, well, what about the little motion, the half-day motion? Why would you fly everybody across the world for that? Well, you don't. But his motion doesn't say this House prefers virtual hearings, for small business, but retains in-person hearings for matters on merits where possible. That's really the position he kind of wound up at. And I think that it is not really what this motion is about. This motion says, the heart of the process is the hearing on the merits. He wants the hearing on the merits to be virtual. I think that anybody listening to this debate, stuck in your kitchen, in your bed, sitting deprived of your trip to Vienna, considering your own future in the profession, can hardly reach the conclusion that it is preferable to isolate yourself from where the real action occurs in a hearing room and live your life on the small screen. I'm sure that the majority of people watching this are not small screen people. They are large stage people who have grand ambitions, and you don't realize grand ambitions on a small screen. Thank you.
Thank you. That concludes our debate. So now, my friends at Arbitration Place, shall we poll our listeners again? The first poll was 61% in favor of preferring traditional hearings. Okay, and then after listening to our noted advocates, what was the second result? Oh, gosh. Well, I think that both of our debaters did very well, and I suspect that Ian's approach to our audience, which is, wouldn't you rather be in Vienna than sitting in your bedsit, had an impact. Neil, don't feel bad on the change of the votes. But we have a few extra minutes, so let's talk to each other as if we were in a breakout room. Few comments.
No. Are we live with the audience or not?
Yes, as far as I know, yes. So Neil, your perception.
Any questions from the audience?
Can we do that? Can we invite questions, Kim and others?
The audience did not pose any questions. However,
okay.
If they would like to, they can use the raise hand function and we can give them permission to speak.
Okay, so if anyone in the audience wants to ask a question, use that function and we will. I would just like to comment that one of the things we didn't touch upon, and it wasn't part of the debate, so that's understandable, is the fact that I think in future we will have hybrid hearings. One of the benefits of virtual hearings, including the final hearing, which is what Ian focused on, is that there can be more participants. Younger lawyers, supporting lawyers, people from far away who couldn't afford to come before. So we may well see that, except in the handful of hearings where credibility is so important and the amounts and the witnesses are so important, that there can be live streaming participation. by other members of teams in a hearing. Another hybrid would be any witness who's going to be questioned just for an hour or a few hours will come in on screen rather than fly halfway around the world and ruin so many trees. So we'll see more flexibility and creativity on the part of tribunals and arbitration place type institutions to get the best of both worlds, real people in one room and virtual. And I'm looking forward to that.
You know, unless we get passports after vaccination, there's still going to be a terrible trouble about quarantine in many places around the world, which is going to make travel very difficult. So we're going to have to live with this for quite a long time. The longer we live with it, the more we'll get used to it.
And for our students, you may not realize that equality of arms means that even if one team or one set of witnesses could attend in person and the other one can't, that means nobody will be able to attend in person, I expect. We'll have quite a period of adjustment. Ian, what would you like to say overall?
It is correct that we're going to be living with this for a long time. I have a real concern about international arbitration. I think the costs are way out of line. Domestic litigation advances much more efficiently, many fewer lawyers. It's become a kind of a cash cow, and I think it has to be reined in. So it's a very large issue. I don't think this motion addressed it. On the extension, lawyer skills in international arbitration vary enormously. I think there's a huge deficit in the ability of young lawyers specializing in arbitration to cross-examine. They really don't understand how to put a question to their own witness if there's a short introduction, and they essentially cross-examine by reading bits of the transcript or a report to the witness and asking them to agree with it. I think there's a huge training deficit amongst the international arbitration bar, and it's something that it's another problem that should be addressed seriously by those practitioners. It should be the pinnacle of international arbitration. Not a place where you can pad your bank account.
And hence the importance of the moot for training. We do have a question from Laurence Marquis, which is to say, what do you two think of segmenting hearings and holding the main hearing in discrete thematic segments over a longer period, perhaps some in person, some not in person? Are you in favor of that, given especially your experience as judges and arbitrators? First, Ian, since you're up.
Yeah, well, I'm not in favor. I think cases move when the pressure is on, and if you have these hearings, 1 week here, 1 week there, 1 week the next where, it's a curse of the courts. People lose track of where they are. The focus is lost because you've done a lot of things in between the segments that are being held. And the settlement pressure is off, so I think it's a bad idea. Sometimes it has to be; there's no choice, but it's a bad idea.
Neil,
I think what segmentation you're talking about. I'm certainly I think we can use virtual hearings better to take off things like jurisdiction, res judicata, time bars, things like that. If we can find a discrete point of law, then that's quite a useful way of dealing with it without all gathering in one place. One thing no one's mentioned is asynchronous hearings, which is where, for instance, the opening by one side is given orally, it's recorded. And so you, the tribunal, and the other side watch it in your own comfortable time zone on the video. And then you do it the other way around. So you've saved a couple of days, maybe, of having to get up early or travel. And then you can build on this for other parts of the case. It's used quite often in China in one of their IP courts, I think. And Michael Huang has written about this. I'm not sure, but it's worth looking at for some aspects of the case.
I agree, unless you're an arbitrator who likes to interrupt openings, which many of us are. Two questions to end with, maybe three. The first is, should we begin to set a minimum standard of tech-savvy skills required by our arbitrators? Is this a new competence for training? That's one question for both of you. And then for Neil, have you actually observed an increase in the number of short virtual hearings that take place, for example, for openings, closings, applications, that you think will continue?
Yes, the answer to the last question is definitely.
And do you think that will continue, I expect?
I think so. I mean, and unless we're all in the same city or London, Paris, you can jump on the train. But if it's flying, even 4 hours, yeah, I think we will do that, definitely. What was the other question? The other part
tech-savvy testing, basically, for arbitrators.
I think that you've got to be patient on that score, because as the older people sort of drop off the end, the younger people coming out will be more tech-savvy. Of course, this is one of the advantages of having an arbitral secretary, because they can help you very much with this. And of course, it's quite difficult for some of the older people to handle electronic documents. And many of my colleagues now only work in electronic documents. You probably too, Lucy, too.
That's right.
I try to, but I do like to mark up sometimes. But I guess, Ian, you probably like hard copies as well?
I do like hard copies, and my experience both in courts and in arbitrations is that, you know, arbitrators tend to know a little bit and have overconfidence in their ability to deal with tech. A lot of hearings are interrupted when the arbitrators press the wrong button on something or other and his system is crashed or he can't find a document. So there should be tech savvy in order to prepare the case, but I'm far happier with the actual hearing and its technical aspects being placed in the hands of somebody else so the arbitrators can focus on the argument.
Can I just say this, that the providers now of the electronic book do all that help for you, and they train you and they get the documents up. So I think, you know, it's working okay. We can manage even though we may not be skilled. There's always someone there in the background to fix something that goes wrong.
Two last questions, which will give you a chance to each in 30 seconds wrap up your views. One is, what have you found works or might work to substitute for the bonding that takes place for a tribunal when you can be together in real person? What happens in two-dimensional life to substitute for that, if anything? And the second goes to Mr. Neil's response to Ian's comments about settlements, prospects, possibilities being hurt when everyone's just online. Are there any, until the pandemic's over and before the next one starts, are there anything tribunals can do to correct for that difference in our two-dimensional world? So 30 seconds each.
I think on the last point that the fact that there was going to be and had to be, if there was going to be a hearing, a virtual one, has led to many settlements, funnily enough. I still don't understand why solicitors can't get on the phone, attorneys can't get on the phone and have a Zoom call with their opposite number and discuss it, just as if they were doing it in the pub or on the way to the toilet. But what was the first point? That was, can't read my writing.
Bonding. How do arbitrators get along now?
Well, I mean, it depends. If you know them already well, then it's quite easy. You have Zoom meetings whenever you want. I agree, it's much better to be in the same room to deliberate, but it can be done on Zoom if you know them well. If you don't know them well, or one of them well, then it is more of a problem, I accept. And there's nothing like the body language, which you can't always get on the screen. But I'm fortunate, I tend to work with people I know, so it's not a problem.
Ian, your last words, please.
Yes, I think they're difficult to find substitutes for bonding in a pandemic era. Neil said earlier that as soon as the Vienna vis moot was restored, he'd be flashing off to Vienna, leaving virtuality behind. So, there will be all the attendant costs and carbon footprints and all the rest of it. But the world is not going to remain in the basement. The world is going to come back together. And I think until that time, there will be a deficiency in getting on the same length and getting familiar with and trusting other colleagues and opposing lawyers. On the question of settlement, I think a lot of cases settle because people are terrified of the process. They may not have had much experience with a virtual hearing. They understand that there won't be face-to-face confrontation. It's like in court when a case is assigned to a judge that nobody has great trust in. There's a very high rate of settlement. You got to get out of there with what you can. So I'm not surprised at the settlement figure.
Okay, I want to thank Kim and Raven and Eric and everyone at Arbitration Place on behalf of Neil and Ian and I for holding this debate. It's been fun preparing and it's been fun doing, and all of us wish you Vis Moody's a successful preliminary round there at Arbitration Place and onward.